Hi everybody and welcome back to Understanding Real Estate Contracts, and this is form number 4, which is the big one, the contract of purchase and sale. This one takes a long time to get through, but believe me, it's worth it. Once you have a basic understanding of the contract, it will make writing a contract, writing an offer on the property that you're interested in purchasing much easier. I will go through some stuff fairly quickly, otherwise this form could take up to an hour to do, so please bear with me. And if you have any questions at any time, you know just to call me. The contract of purchase and sale has a page at the front, which is not a portion of the contract that I'm scrolling through right now. What is on there is all the details. It's explaining the definitions of what certain terms of the contract mean. What's really important in here that's not noted anywhere else in the contract is the costs that are borne by the buyer. These costs here are such things like your legal fees, land and registration fees, title searches, anything else that might be required by your mortgage company in order to secure the mortgage for you. You have to have a fire insurance on any property. If it is a strata, fire insurance is not mandatory because it is part of the strata. However, you will need content insurance and liability insurance to go with that. There's sales tax if there is a GST or a sales tax is applicable. If it's a new property, that's the case. If it's not applicable. And there's property transfer tax. This is the big one. 1% of the first 200,000, 2% of the remainder. Then once you get over a couple $1 million, it changes again. So the fees can be quite extensive. When we write the offer, I'll actually go through this and break down for you all the costs that you have so that you're fully aware of all the costs associated. So let's move on to the actual form itself. Basically, the contract of purchase and sale indicates that McDonald Realty is the brokerage that I'm working with. And let's just say we've got the sellers. Their names are listed there. Your name is listed over as the buyer, as well as information about you. Then there's the address of the property you're purchasing. And what's significant and most important here are the PID number and the legal description. We will take those from the title just to make sure that they are correct, and we'll insert them in there. The purchase price that you're paying is written both numerically and, with letters, alphanumerically. That's a good question. How does that go? Anyways, it's written and it's written numerically. Then on top of that, we have the deposit, which is the amount that you're paying upon subject removal. This amount of money is required within 48 hours of final subject removal and is due paid by bank draft or direct deposit. So you can deposit it directly into our account, but we then need to get a photograph of the receipt to confirm that that money has been deposited in the account. All the money that's held in the account is held in a trust account with McDonald Realty. And McDonald Realty is governed under the Real Estate Services Act as far as how we handle that money. But that's all written down there, so you're welcome to read it. Basically says that we're obligated to hold it under certain terms. Section 3 basically outlines all the terms and conditions. Now I want to explain something here that I think is quite important. All of the clauses that are subject clauses have a date. Usually those are anywhere between 7 to 14 days after the acceptance of the offer. We have that amount of time to satisfy the subjects. Understand that all of these subjects are written as whim and fancy clauses or escape clauses. This protects the buyer under all circumstances. For example, the first clause is subject to the buyer being approved for and satisfied with the terms and conditions of financing being sought. And what that implies is that you have to be fully satisfied with your financing. If you're not satisfied for any reason whatsoever, then you can walk away from the contract. Hence why it's called a whim and fancy or an escape clause. The clauses that are typically in here, number 1 is the financing clause. Number 2 is the fire and property insurance. You have to verify that you can get that. Number 3 is obtaining an inspection report against any defects or concerns that create a value being owed of over $1,500. Then there's subject to you reviewing and approving the property disclosure statement. That's the form that they've filled out to say everything they know that's right and wrong with the property. You'll see a copy of that once we've submitted the offer. Then there is subject to you reviewing the title search. With the title search, there will be encumbrances and liens on the property. And it's just really important that we get that document off to your lawyer to have your lawyer review it. It's also subject to you getting a survey. Now, if this is a strata property, a survey isn't necessary. However, it will identify things like common property and limited common property on the survey. Most people won't have it, but it will be within the strata docs that we're provided with. It is also subject to you getting legal advice. So the legal advice you receive would be providing your lawyer with the contract of purchase and sale, as well as providing them with the title search and any other documents we have associated with the contract. They can review those quite quickly, and most lawyers will do that as part of your closing package. So don't be afraid to offer that to the lawyer, and they will review it for us. There's a warrant in here that goes from page 1 to page 2 that basically states that the seller will warrant that there is no underground oil tank, and if there is one, they are deemed liable to pay for its removal and any soil remediation for the lifelong term of the property. When we write this in, the majority of people, majority of sellers and agents will cross that out and say they're not going to do that because they don't know if there ever was 50, 60, 70 years ago some sort of oil tank on the property, and they're not willing to take liability for that. In that case, we recommend that we get Tank Tech in there and they will scan the property to make sure there is no oil tank on the property. Costs around about $200 to do that. Then when we go down, there are such things as that we get a letter of permission from the sellers to allow you to request all documents from the District of Squamish. This is just to make sure any building permits and such have been pulled out when they've done any work on the property. It's also the seller agrees to have the carpets cleaned and the premises professionally cleaned. Just so you're 100% aware, there's virtually no way for us to guarantee that this is done. Even though later in the contract we do have an area where 24 to 72 hours, we are allowed to do a walkthrough on the property just to make sure that everything's okay. They might still not have cleaned yet. So it's very difficult to prove that. And just so you're aware, people's opinion of professionally cleaned is very different. So keep that in mind when we get to the closing of the property. The appliances will be in the same working order as when you saw the property. And you understand that they're not brand new, and so they are used appliances. They'll provide us with any receipts and warranties associated with the property. They'll also provide us with the waste disposal and compost bins that come with the property. They'll provide us a survey certificate if one is available. And if we require, if there is a wood burning fireplace or any wood burning appliance on the property, we'll be requesting a wet certificate from them. That allows you to get insurance on the property. If there's a wood burning appliance and it does not have a wet certificate, you will not be able to get insurance. So we must be aware of this at all times. There's the information again about the property transfer tax. As we said, it's 1% of the first 100,000 and 2% on the value up to $2 million. And then it's 3% above that. So it becomes quite expensive as we get to the higher properties, but it is quite a price tag to have to pay, and you must keep that in mind. The seller agrees to allow you to do the walkthrough. That's what I mentioned, 24 to 72 hours prior to completion. We'll give them notice and we'll do a quick walkthrough just to make sure everything is okay. And the seller agrees to provide a seller's lawyer, upon request, proof of citizenship. This has become an issue recently because you could be on the hook for any tax implications should they not be a resident of Canada. So we leave that up to the lawyer. We get the lawyer to request the documentation from the seller. And that way we can confirm that you're not going to have any hidden costs that you're not anticipating. Those can be quite substantial, so we've got to make sure of that. When it comes time for a strata document or contract, you'll see that there are certain things with a strata that are different than when you have a detached property. When it's a strata, there are strata meeting minutes that are kept for about 2 years that we'll have for 2 years, we'll request for 2 years. There's also a Form B. There's also often a depreciation report. All of these forms are required for the seller to provide to us, and for us to be satisfied with that there's nothing in there that we feel sort of doesn't add value or detracts value from the property. It also states that if a special levy is voted on or approved prior to the completion date, so before you take completion or possession of the property, if there was a special levy voted on and they actually decided that they were going to charge a levy for replacing the roofs, that would be the burden of the seller to pay. However, if it was voted on or approved after you take possession, then it's solely your responsibility. Even if it has been talked about in the meeting minutes, if it's not voted on or approved, the person responsible for paying for that is the person who is the owner at the time it is voted on or approved. So now we get down to the section 4, 5, and 6, which refers to three different dates. There's the completion date, which is the date that you must pay the money to the seller. Then there's your possession date, which is the date that you actually physically move into the property. And we also denote the time that you move into the property. Then there are the adjustments. The adjustment date is the date that you become responsible for the property, paying property taxes, paying strata fees, having insurance, that sort of thing. It's the adjustment date that is a critical date for you. Included items. Just so we're clear, all included items are anything that is attached to the property. For example, if a mirror is hung on a wall, then technically they have to leave the hanger, but not the mirror. TV brackets become a big concern because they are bolted into the wall. So we will put those in the contract if there are TV stands that are wall mounted. Other standard things are fridge, stove, washer, dryer, dishwasher, and microwave, because those are things that are not physically attached to the property. So we have to write them down as separate included items. There's also all window coverings are included unless they write them down as an exclusion. We also request that you get 2 sets of keys, garage door openers, and of course anything else that's not attached to the property, but maybe something that you'd like to write into the contract. We can always do that. There's also a section there where they can exclude items that they want. A great example of this is a dining room chandelier that has some family value to them, and they ask to have that written out. Sometimes they'll replace it with a generic one, and sometimes they'll just leave a cover plate so that you can actually install the chandelier of your choice. Number 8 is that the property has to be in the condition as you viewed it. Title is free and clear of all encumbrances. This is outlining the fact that when you receive a property or purchase a property, the seller is responsible to give you the title free and clear of all encumbrances. So they have to take all the financial encumbrances off title. Understand that non-financial encumbrances can still be on title. Things like rights of way or easements can remain on title because they go with the property. Tender, all monies must be paid by way of certified check, bank draft, cash, or lawyer's notary's check. It says that, but reality of today's world, it's all done digitally. Documents, section number 11. Basically, everything must be received at the Land Title Office by 4 p.m. If it's not received there by 4 p.m., then it's not deemed as being received on time. And with time being of the essence in contracts, that can be an issue. The seller's particulars and residencies. This is what we were referring to when we asked the lawyer to confirm the citizenship of the client. The realtor on the selling end of the property is responsible to do a FINTRAC form which identifies them as a Canadian citizen. However, it is possible that the form that was taken doesn't prove that they're a Canadian citizen. So we need to make sure that this is the case, especially under the Income Tax Act, that they have to file income taxes in Canada. That's where it becomes a pertinent issue. 11B is the GST certificate. It basically states that the seller has to provide a GST certificate, especially if they're an out-of-town resident, if they're not a Canadian citizen. And that's something that your lawyer will go through with you. We need to make sure that that's the case. Time is of the essence. Anytime there is a time frame on a contract, be it a date or a time, if the requirement for that time is not fulfilled, then the contract is automatically deemed null and void. So if you have to remove subjects by a certain date, failure to remove those subjects will mandate that the contract is null and void. Buyer financing. This section and section 14, clearing title, are very similar, but one is from the buyer's perspective and one is from the seller's perspective. It basically states that the order in which things happen between title transfer and money transfer, and this is something the lawyers handle. Essentially, as you can imagine, the seller cannot give you a title free and clear of all encumbrances until you pay them. You can't pay them until you get your mortgage money, but the mortgage company won't give you the money until you have a title free and clear of all encumbrances. So it's a bit of a catch-22, and sections 13 and 14 basically go through the process by which that we assure that that happens, and the agreement both buyer and seller take in the understanding to make sure it's a smooth process. Section 15, costs, we've already been through on the front of the contract. We talked about those. Those are the costs that we're referencing. Risk, obviously there's risk associated with purchasing a property at any point in time. Plural basically says that your heirs and successors are responsible to fulfill the obligations under the contract should you pass away. That is essentially what it means. Then under representations and warranties, there are no representations and warranties made by any party other than what is in the property disclosure statement. It warrants a moment to explain that a property disclosure statement is everything the buyer or everything that the seller knows to be wrong with the property or right with the property. The key there is that it's to the best of their knowledge, and there becomes a bit of a gray area there, and we'll go through that when we're actually signing off on the property disclosure statement. Personal information, this is the privacy consent form that we've already filled out prior, but they do put it in the contract just to make sure that everybody's aware of how the Personal Information in the Privacy Act works. The assignment of remuneration basically describes that we're eligible to receive our compensation for fulfilling our obligations under the contract once the property has completed. There are question marks on that as to the obligation to pay that money actually comes at the time subjects are removed, because that is when a contract is deemed to be firm and binding. In other words, you must agree to purchase the property once you've removed your subjects and paid your deposit. At that point, you are legally obligated to purchase the property. As such, the realtor becomes legally entitled to their commission. Restriction of assignment of contract is basically explaining that you cannot assign this contract to another party unless they have given you written consent to do so. This was put in the contract only a couple of years ago to prevent what was happening before of the shadow flipping, where people were flipping properties and the original seller didn't even know who was buying the property. Agency disclosure, this is part of the disclosure of representation trading services and discloses that I'm going to be representing you and that the seller will be represented by whatever agent we put into the seller's representation field. If there's an unrepresented party happening, or if there is potential dual agency, neither of which should happen when you're being represented by myself, then we will go through it at that time, but I don't see that being an issue. On the last page of the contract is the notation that acceptance is irrevocable. Now, once you agree and the seller has accepted your offer and you guys have agreed upon all of the terms in the contract, you can't just walk away and say, no, I'm not buying it. The seller can also not walk away and say, I'm just not going to sell it. It's irrevocable. You can't just walk away from the contract. That being said, you do have your subjects, and your subjects do allow you some leniency with what you can use to walk away from the contract. The seller, unless there are subjects in there for the seller, they have no way to escape the contract, let's say. The offer is always left open until a certain time frame. Usually you leave it open until the end of the day if the contract is written in the morning, or perhaps early the next day, depending on the immediacy of the contract. If this is a property that we're concerned is going to get snapped up by somebody else, we are going to leave that time frame much shorter than we would in otherwise. Down here, when the seller accepts the offer, they will sign acknowledging that they are a resident of Canada, as you will have done actually up in the upper form there as well. And they will put the date in that they've accepted your offer. Also understand that they'll put the date in there, but they also might make changes to the contract. Once they send it back to us with those changes, we have the option to change it back to things that we would like, and that's where the negotiation happens. Once all of this is done and everybody's signed off on it and everybody's agreed to all the terms, we then have a contract of purchase and sale that is deemed an accepted offer. It is then up to us after that point to walk you through the steps required to remove all of your subjects to get a firm and binding contract and purchase the home you're looking to buy. We look forward to helping you out with this process, and should you have any questions at all, call me at 604-892-8155, or you can email me, simon@simonhudson.ca. Thanks again and have a wonderful day.